again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, he's still out there. So I don't know how bad you can hear him. He's like a little bit away. So I thought, well, we'll give this a whirl. How's everyone doing? Good to see you, Nicole. Good to see you, Dan. Oh my word, Jazzy. So I'm going to go through a couple of the documents that have been released as far as Richard Allen goes. And then I was saying tomorrow, I also wanted to do something on the Miller hearing as far as Ethan Crumbley goes. And I also wanted to do oh, that's right. Harmony. Those maps and stuff from Mind of Monsters. So I will set this up. I hope that's not too bad in the back. I am going to see what the best one is for you guys. So I'm not going to do a ton. I think there's 4 different documents. One is, I think, 22 pages or something like that, and there's a lot in there. But I thought what I would do is go through the documents myself and highlight what is important. And all of the little statutes and codes and all of that fancy stuff, we'll wait until another time and just do that in one single stream if we happen to be able to do it. So, oh yeah, he's having a great time out there with this snowblower. I do believe he's moving his way to the street. Yeah, I don't like that. It's not big enough for you guys. No. Okay, that's probably the best that I'm going to get. So this is, I do believe, yet 9 pages. And it is the motion to dismiss for destroying exculpatory evidence. So I find this one fairly interesting. Let me know if that's too much and the sound, and we'll do something else while he's out there ridding himself of all the snow. So comes now the accused, Richard Allen, by and through a counsel, Andrew Baldwin and Bradley Rossi, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 12 of the Indiana Constitution, and gives the code, moves this court to dismiss charges against the accused for destroying exculpatory evidence in violation of the standards set out in Brady versus Maryland. In support of said motion, the accused states the following. 1. Richard Allen stands accused of deleting 2 victims on or about February 13th, 2017. 2. Since receiving discovery on this case, the defense has unearthed significant evidence that third parties, now they're naming people again, and this just is a couple of days ago. So they're back to bringing up Brad Holder and Patrick Westfall. So if you're not familiar, Brad Holder is all about Odinism. I've actually brought something up for us to look at. So Brad and Patrick Westfall. Yeah, and we're getting right back into the Odinism stuff here. So, since receiving discovery on this case, the defense has unearthed significant evidence that third parties named Brad Holder and Patrick Westfall were both involved in these deletings. The evidence is critical to the theory of the defense. The defense would incorporate into the motion the contents of a Frank's memorandum that was filed with this court on September 18th, 2023, which provides the details of the evidence that supports Brad Holder's and Patrick Westfall's involvement in these deletings. 4. In discovery, the defense found a document dated February 17th, 2017, that appears to be an FBI report memorializing an interview with Brad Holder. Contained within the document are these words. The below is an interview summary. This is not intended to be verbatim and does not memorialize a statement, all statements made during this interview. Communications by parties in the interview room were electronically recorded. The recordings captured the actual words spoken. Emphasis on added. 5. Also in discovery, the defense found a document dated February 19th, 2017, that appears to memorialize an interview with Patrick Westfall. The report itself does not indicate whether the interview was recorded, although the defense would expect that standard procedure would require video or audio recordings of all statements. 6. After locating this document, the defense sought a copy of the recording detailed in the February 17th, 2017 report so that the defense could listen to the exact spoken words of Brad Holder during this interview. That is vital to Allen's defense, particularly the statements that the author of the document admits were not memorialized in the document. Also, 7, the defense requests a copy of all audio, video of Patrick Westfall's interview that was memorialized in February 19th, 2017 report. Okay, guys, I just seen hubby move my vehicle up. So, he could be getting closer with that thing. So 8, on September 8th, 2023, the prosecutor communicated in a letter that there were no audio or video interviews of Brad Holder or Patrick Westfall available. Prosecutor McClelland offered no explanation as to why these didn't exist. Here we go. Before the defense had an opportunity to investigate the reason why these material pieces of evidence were not available, Prosecutor McClelland called for the disqualification of attorneys Rossi and Baldwin. You see, I just think that he is sus AF, you guys. I do. Slick Nick, ooh, I don't trust him. I just think that there's something going on in that area. I haven't figured out quite who and exactly where and what it, if anything, has to do with this case. But this Odinism stuff, it keeps coming out and it keeps coming out. And then we find out McClelland is went to a church. Was it him or his dad went to church with Brad Holder or his? I'll look for that connection again, but it's a close one. It's just like, what? But these are small towns. Okay, prosecutor McClelland called for the disqualification of attorneys Rossi and Baldwin as Richard Allen's lawyers. Judge Gull, without a great deal of hesitation, said she was leaning towards granting McClelland's request. Ultimately, Judge Gull called Rosie and Baldwin to be taken off the case. How is that? The Slick Nick gets to pipe up when it comes to this decision. It makes no sense to me. Ultimately, Judge Gull caused Rosie and Baldwin to be taken off the case. This occurred before Baldwin and Rosie learned of why crucial videotaped interviews were missing. 10. On January 31st, 2024, after being reinstated to the case, the prosecution turned over discovery to the defense, including a letter cataloging the evidence that the prosecutor was turning over to the defense. 11. Contained on page 5, paragraph 5 of the itemization of discovery are these words that explain Brad Holder's missing videotaped interview and Patrick Westfall's missing interview, if one ever existed. So yeah, this is talk about negligence. Holy crap. Unreal. Due to a DVR program error discovered on 9/20/2017, all recordings up to February 20th, 2017 were recorded over. There is no detectable audio found on this drive. Remember, Brad Holder and Patrick Westfall were interviewed during this very short window, February 14th, 2017 to February 20, 2017, literally days after this happened. That's brutal. The videotape interviews were deleted by the police. It is unknown what other interviews were deleted during that relevant time frame. The destruction of material, interviews of key suspects early in the investigation demonstrates negligence, if not intentional conduct, on the behalf of the state. I'd have to agree. I mean, they went after Baldwin for somebody stealing something out of his war room, and these guys are like deleting evidence and recording over evidence. And with the way things are going with, I mean, the law enforcement in that area, we're just learning not to trust them. And this is just adding to that. Serious crimes recorded over interviews of material suspects with reckless or intentionality. 12. As a material part of the defense, Richard Allen is expected to direct the attention towards Brad Holder and Patrick Westfall as being involved in these deletings of 2 young victims. The evidence will show that Richard does not know Brad Holder or Patrick Westfall, and therefore that Richard Allen had nothing to do with these deletings. The destroyed videotaped interview of Holder and Patrick Westfall, just what's the luck? If it ever existed again, was expected to contain evidence that would provide exculpatory and material evidence in support of Richard Allen's defense. Ooh, I think it's going off. Turn it off, babe. Turn it off. Oh, no. Oh, no. Okay, so was expected to contain evidence that would or could provide exculpatory and material evidence in support of Richard Allen's defense. If a recording of Westfall was never secured, that too is purposeful or negligent failure to preserve material and exculpatory evidence. Yeah, they're worried about Bradley and Rosie. Give me a break. This is worse. I mean, it's all bad. There's nothing good about any of this. So 13, experienced defense lawyers fully understand the significance of comparing and contrasting the accuracy and credibility of one's video audio tape statement with that information, which is represented by law enforcement officers in police reports and or summaries. So how bad is this for you guys? Oh my God. I'm finding it really loud. He might be almost done. Hang on for 2 seconds. It's damn loud, guys. I thought it was done. Come on. You can do it. Oh my. Are you kidding me already? Are you kidding me already? Sorry. I thought he's got to be done. Now I'm worried if he's going to pull it out here in the patio. Okay, let's see if we can do this. Okay, so oh boy. It is through this process that Richard Allen would have to challenge the veracity of the statements of Holder and Westfall. However, the state's intentional or negligent destruction of the original records deprived the accused of such an opportunity. This is true. What's that? It might be down a little bit now. I'm like, are you kidding me? It's loud. I thought he was just going to do our area. And I thought, okay. Well, then you went 2 houses that way, 3 that way. And I don't know what he's doing now. Is it pretty loud, Chopper? Is it pretty bad? I don't want to put you guys through this. He does. Oh my God. Oh my God. I don't know. Snow blowers and hammers right here. Or shovels, not hammers. Good Lord. Okay, let's try this again. See if we can get some of this done. Okay, so we're at 14. The state's actions have deprived the defense of the ability to compare Brad Holder's words from February 2017, February 17th, 2017, only 3 days after the victims were deleted, to the evidence that was unearthed over the next several months, weeks, months, and years. This would have allowed Richard Allen to determine whether Holder's story was consistent with unknown evidence at the time of Holder's first statement, and whether it is consistent or inconsistent with future testimony, be that trial testimony or deposition testimony or statements made to other persons or witnesses. In any criminal investigation, the interviews of potential witnesses must be preserved, such as the precise words of Holder and Westfall in their 2017 interviews, because as additional information is developed, reviewing prior to statements may reveal inconsistencies or raise questions about the witnesses or other information relevant to the unbiased investigation. I would have to agree. Like, you want to talk about a big mistake. Oh my God, isn't that something? Oh my God. I mean, yeah, a person just wants to like get at that guy. You know what I mean? I I have a I'm sure the same as everybody. I got problems with Adam Montgomery even breathing our air. Okay, so without actual audio video that would provide the exact spoken words from Brad Holder's mouth, the accused Richard Allen will never ever be able to know exactly how many inconsistencies existed in the original statement of Brad Holder and Patrick Westfall when they compared their evidence to what was later discovered or future testimony of Brad Holder and Westfall. Nor can Richard Allen challenge the credibility of Holder and Westfall in light of subsequently discovered evidence. Furthermore, Allen is deprived of the ability to confront either suspect with their own words contradicting any self-serving testimony that may offer throughout the investigation or prosecution. So 18. On August 30th, 2023, following depositions in which the state of Indiana and law enforcement learned that the defense believed Brad Holder to be one of the actors in these deletings. Law enforcement finally re-interviewed Holder for what is believed to be the first time since 2017. Yeah, those recordings would be awfully handy, wouldn't they? You know, and the funny thing is Brad Holder, this POS, his son dated Abby. So white supremacist and heathen Odinist, whatever he wants to call himself today. So, Brad Holder told law enforcement that he never met Abby Williams, who was purportedly dating his son. His story changed in 2023 when he talked to law enforcement. In 2023, Holder told the interviewer that at the 3909 mark, I barely even knew that girl. I met her once. Therefore, one material and highly relevant contradiction. Contradictions would be available to the defense, but for the state's intentional or negligent failure to preserve all of the evidence. Yeah, this is pretty bad. Such negligence and intentional conduct on the part of the police has also resulted in the absence of material evidence which could be exculpatory in nature. The circumstance in of itself violates Richard Allen's due process rights. We must, however, place such conduct in a greater and more noteworthy context. You know, I don't know if Brad Holder has anything to do with this, but I tell you what, he absolutely had, there has to be a deeper dive done on this guy. Like, his name's coming up way too often, both of their names, and they're twisted humans. So, has also been discovered that former Rushville police officer Todd Click reached out to prosecutor McClelland in an attempt to bring this to his attention. The existence of an 85-page report summarizing the investigation that revolved around Brad Holder, Patrick Westfall, and other affiliates. This letter, which landed on prosecutor McClelland's desk via certified mailing on May 1st, 2023, was not discovered to the defense until more than 4 months later on September 8th, 2023. That's brutal. And only after the defense disclosed in depositions that they were aware of the Odinist ties to the crime scene and investigation. This failure to disclose on the part of the prosecutor, if not entirely intentional, rises to a level of an untimely failure to disclosure of potentially exculpatory evidence. The failure to disclose sheds further suspicion on the absence of the Holder and Westfall interviews referenced herein. Yeah, those would be really, really nice to have, hey? Because he's not eliminated, not in my mind. So 22, furthermore, as explained by the Frank's motion, it appears as if law enforcement and possibly the prosecutor himself attempted to conceal the identity of a Purdue professor who contradicts the sworn words of Trooper Jerry Holman and Sheriff Tony Liggett. That for whatever reason, I'm just putting this out there, Sheriff Tony Liggett is the same size as Richard Allen. And so Trooper Jerry Holman and Sheriff Tony Liggett concerning whether the crime scene contains signs of the involvement of an Odinist cult. 23. In more recent discovery, defense has also located a prepared search warrant application to AT&T for data contained on Brad Holder and Patrick Westfall's mobile devices. Boom. Each applicant states that Holder Westfall is a known member of a religious sect, and elements of the M may have potential religious significance. The information being requested is relevant to an ongoing criminal investigation. There is no evidence that the warrant was ever served. Also, the defense has not located any discovery regarding any data contained on Holder and Westfall's 2017 phones or any other electronic devices. It defies logic that law enforcement would conduct forensic examinations of so many other phones in its investigation, yet ignore the phones of Brad Holder and Patrick Westfall, who were viewed as suspects within 3 days of these deletings and interviewed by law enforcement, who then prepared search warrants for those phones. These suspicious facts further call into question the circumstances surrounding the destruction of key videotape statements of Holder and Westfall, if again it ever existed, and support Richard Allen's motion to dismiss All charges filed by the state of Indiana. Defendant requests a hearing at which time he can present evidence and make arguments as to why these charges should be dismissed. 25. The defense files contemporaneously herewith his memorandum in support of the motion. Wherefore, Richard Allen, for reasons cited herein and in the accompanying memorandum, moves to dismiss all charges against him and requests a hearing on this motion. Comes now Attorney Bradley, A. Rossi, and Attorney Andrew J. Baldwin, and swear and affirm under the penalties of perjury that the facts stated herein are true and accurate to the best of their knowledge. Signed by both lawyers on the 7th day of February, which means 2 days ago. Hi there, sweet misery. How you doing? How you doing, friend? It's quiet in here tonight, but great to have you. So let's see here. There's another document. And hopefully the snow blowing will be done. Okay, this is one for later. So this one here, State of Indiana, is the plaintiff versus Richard M. Allen, the defendant. The court, having defendant's verified motion to disqualify, filed January 28, 2024. Defendant's affidavit, filed January 28, 2024. A certification of Richard Allen's attorney, filed January 8, 2024. Under advisement and having considered the pleadings, now denies the verified motion to disqualify without hearing, as the Indiana Supreme Court unanimously denied defendant's previous request on January 18, 2024. Again, CC to all the lawyers. I don't know, guys. I honestly don't know. So what have we got over here? Take a peek over here as well. Take a look at this. Yeah, it's been a very, very busy day, so I'm not 1,000%. I just want to make sure I've got the right one. It's this. Okay. So this was February 7th, again, 2 days ago. Sorry, I thought that there was a video in here for us. No. I was mistaken. Attorneys representing accused Delphi deleter Richard Allen are seeking to have the charges against him dismissed, claiming that the police intentionally or negligently destroyed exculpatory evidence. That's the truth, in my opinion. Meaning evidence supporting Allen's innocence. The filing is the latest dramatic development in one of the most high-profile deleting cases in Indiana history. Yeah, I streamed for 8 hours already, so I'm a little tuckered, but I wanted to share this stuff with you. And then hubby decided to start snow blowing, so that's what that is, if you weren't here earlier. So Allen is facing 2 counts of M while committing or attempting to commit napping, as well as 2 counts of M and 2 counts of napping in the February 2017 deleting of Williams and German, who were discovered in a wooded area just off the Delphi Historic Trail system. They vanished while walking on the Monon High Bridge Trail near Delphi, Indiana, February 13th, 2017. The trail traverses an old abandoned stretch of what was once the Monon Railroad and crosses over an old trestle over a small river or creek that the girls were found deceased the following day. Not, it says here in an area, oh, okay, yeah, in an area near the trestle, and determined to be. So in the motion, Ellen's attorney accuses police of destroying exculpatory evidence, specifically recorded interviews with two supposed key suspects. So they were interviewing these two back on February 17th, 2017. And here they chose not to disclose those names. We did earlier, but their names have been all over the place. However, the state said in September they did not have any recordings of the interview and offered no explanation as to why these didn't exist. Prosecutors subsequently sought to have Ellen's attorneys, Brad Rossi and Andrew Baldwin, removed from the case. But it was the prosecution that screwed up. So yeah, there's that. So it says the duo were controversially removed by special Judge Fran Gull Shitbird in October before the Indiana Supreme Court reinstated them last month. Upon being reinstated, Rossi and Baldwin say prosecutors told them they had accidentally deleted any such interviews due to a DVR program error discovered on September 20th, 2017. All recordings up to February 20th, 2017 have been recorded over. Prosecutors wrote in a letter catalyzing the discovery evidence provided to Ellen. There is no detectable audio found on this drive. The motion emphasizes that a key part of Ellen's defense hinged on direct attention towards the two interviewees as being involved in the deleting of Williams and German, reasoning that failing to maintain all of the records of those who interviewed amounts to violations all of Ellen's due process rights. And yeah, this was not shown to the families. This was not shown to the lawyers. We just know that they were there at one point. So Gull on Wednesday also denied the latest motion from Ellen seeking to have her removed as a presiding judge in the case, a request the Supreme Court previously rejected. In the order, Gull wrote that she denies the verified motion to disqualify without hearing, as the Indiana Supreme Court unanimously denied defendants' previous request on January 18th, 2024. Hearing to discuss prosecutors' request to have Baldwin and Rossi held in contempt of court for allowing the leaking of evidence in the case and bringing additional charges is scheduled for February 12th, but Ellen has filed a motion to vacate the proceeding. Yeah, he's just a peach, guys. Okay, let's see here. I'm just seeing if there's anything here. If we'll just go to the other tab with Baldwin, not with Baldwin, with Holder. We're talking here how he is it's justified having Richard Allen in that Wabash prison right now. I'm not so sure if that's right or not. It sounds like his lawyers have to, I think it's a 2-hour drive or close to. So they also claim that Gull lacked the authority to remove counsel without considering others' less drastic options and weighing the prejudice to Allen. The justices claimed that if the Superior Court did not intervene to reinstate Allen's attorneys and he were to get the conviction vacated on an appeal over that issue, it could produce years of further delay. This is the thing. The Supreme Court justices then lay out 3 criteria where a judge could remove a defendant's counsel over the objection of the defendant and their counsel. So disqualification is the last resort. Disqualification is necessary to protect the defendant's constitutional rights, to ensure the proceedings are conducted fairly and within our professional ethical standards, or to ensure the orderly and efficient administration of justice. Those interests outweighed the prejudice to the defendant. As such, the justices said that the judge could have handled her issue with Allen's attorney through regular court proceedings. So it was not a last resort. The justices said his attorneys have for years, if not decades, of experience that makes them qualified to act as his counsel. And his attorney's statements on the case did not undermine the defense. Strictly, the justices said Gull's concern to not outweigh the substantial prejudice to Allen from substituting counsel. Let's see what we've got here, friends. Well, do you know what? I think for now, that's where we'll stay. We went through a couple of the documents, kind of letting us know where we're sitting. There's a couple longer ones that I will go through. And once I've kind of looked through them, I'll come to you guys and we'll have an abbreviated view of them. So guys, thanks again for being here with me. It was a long streaming day, so I appreciate you. Don't forget to subscribe, like, and share. And I'll see you guys in the next one. Bye.